Kapag may krimen, ang tanong agad ng karamihan.
Sinong may kasalanan?
Paano ba siya mananagot?
At syempre,
Paano namin makakamit ang hustisya?
pero teka, alam niyo ba na ang pagbibigay hustisya hindi lang trabaho ng korte? Ito ay trabaho ng criminal justice system na siyang sistema kung saan ang mga taong nakagawa ng krimen ay iniimbestigahan, hinuhuli, sinasampahan ng kaso, at hinaharap sa korte upang patunayan ang sala niya. May 5 haligi ang criminal justice system at bawat isa may mahalagang papel. Unahin natin ang law enforcement. Ito ang mga ahensyang nagpapatupad ng batas, gaya ng PNP, NBI, AFP, at iba pa. Sila ang mga unang rumeresponde kapag may krimen. Sila rin ang nag-iimbestiga, umaaresto, at tumutulong sa mga biktima para makapagsampa ng reklamo. Pangalawa naman, ang prosecution. Kapag may inaresto o inireklamo, ang prosecutor o fiscal naman ang sumusuri kung may sapat na basehan para kasuhan ang isang tao. Kung meron, sila ang naghahain ng kaso sa korte at nag-uusig sa paglilitis. Pangatlo, ang judiciary. Dito na pumapasok ang tungkulin ng mga korte. Ang taong sinampahan ng kaso na hindi saklaw ng summary procedure ay maaari na agad magpiyansa o di kaya ay magpetisyon para mabigyan ng piyansa. Sa paglilitis, inihaharap ang ebidensya at mga testigo at ang husgado ang magpapasya kung guilty o not guilty ang akusado. Kung siya ay mapawalang sala, tapos na ang kaso at maaari na siyang palayain. Kung guilty naman, pwede nang bunuin ng sentensya o kaya ay maghain ng mga remedyo ayon sa batas. Kapag naging pinal na ang hatol, ipapataw ang parusa gaya ng community service, multa, pagkakakulong o kombinasyon ng mga ito. Kung ang sentensyang pagkakakulong ay hindi lalampas sa 6 na taon at siya'y kwalipikado, maaaring siyang payagan sa probation. Pang-4, ang corrections. Ang mga napatawan ng sentensyang pagkakakulong ng higit sa 3 taon ay mapupunta sa kustodiya ng Bureau of Corrections o Bucor. Kapag hindi hihigit ng 3 taong pagkakakulong ang parusa, pati na rin ang mga may kasalukuyang dinidilig na kaso at hindi nakapagpiyansa ay mapupunta sa Bureau of Jail Management and Penology o BJMP. Dito sila sasailalim sa mga programang rehabilitasyon at pagbabago para sila ay maging kapaki-pakinabang na mamamayan matapos pagsilbihan ang kanilang parusa. At panghuli, ang community. Ito ay binubuo ng iba't ibang ahensya ng gobyerno katulad ng barangay, DSWD, NGOs, simbahan, at iba pa. Sila ang katuwang sa pag-iwas sa krimen at pagsuporta sa mga taong lumaya na para makapagsimulang muli. Sa madaling sabi, ang pagkakamit ng hustisya ay trabaho ng kabuuan ng 5 haligi ng criminal justice system. Na ang krimen ay mapanagutan at ang nagkasala ay magbago at maibalik sa komunidad. Lahat ng haligi ay may papel para sa hustisya, para sa katahimikan, at para sa isang lipunang mas ligtas at makatarungan.
Good afternoon once again, Your Honors and distinguished guests. I trust that we have had a good lunch and we can proceed now to our afternoon session for the 3rd day of our 2nd National Decongestion Summit. So we have a very interesting discussion this afternoon because we will be talking about this concept of uniting correctional systems. So quite controversial for some, but we're looking forward to an interesting discussion. This session will examine how the proposed unification of the Bureau of Corrections and the Bureau of Jail Management and Penology into a single integrated correctional system anchored in the Nelson Mandela rules and international standards. So how can we achieve that? And to join us for this afternoon's discussion, let me call on stage our panelist and our moderator. We have with us the Inter-Regional Advisor of the United Nations Office on Drugs and Crimes, Mr. Philip Meissner. We also have Attorney Mary Grace Casano, Executive Director for Legal Aid and Secretary of the Integrated Bar of the Philippines Cebu City Chapter. And finally, Dr. Raymond Narag from Southern Illinois University, Carbondale. And to lead our discussion, let me call on Associate Justice from the Court of Appeals, Michael P. Ong. Justice Maki.
Good afternoon, everyone. Did we all enjoy our lunch? Me too. The problem with being the session right after lunch is the blood that's supposed to be in our brains right now is now in our bellies. And it might be an extra challenge for some to pay attention. But I'm not worried because the topic we have for this afternoon, I'm sure, will make that blood in our bellies shoot right up back to our brains. Our topic today is from fragmentation to unification of the correctional system consistent with the Nelson Mandela rules. It's an important topic for anyone with even a modicum of interest in the correctional system in the Philippines and its impact on the welfare of PDLs. And this afternoon, we are very much privileged to have with us panelists who, between themselves, have a wealth of knowledge on prison and prison reform. Not just knowledge in terms of book knowledge, but knowledge based from experience. And we should all look forward to what they have to say on this topic. Our first speaker is Mr. Philip Meisner. Mr. Meisner is the Interregional Advisor in the UN Office on Drugs and Crime, or UNODC. He was a team lead on prison and penal reform, or is the team lead on prison and prison reform in the UNODC. He was instrumental in the intergovernment process that led to the Nelson Mandela rules. And he also provided overall guidance in developing the UNODC toolkit on those rules. Mr. Meisner has visited prisons in 50 countries in all continents and provided advice to the justice officials in different countries in the world. So here to talk to us about what international standards and the experience of other nations have to say about this issue, I present to you Mr. Philip Meisner.
Thank you very much for the kind introduction, Justice Ong. Distinguished participants, ladies and gentlemen, good afternoon. Let me first of all please echo previous speakers and commend JSSC for convening this second National Decongestion Summit and to remain seized with tackling what remains one of the most formidable prison challenges, not only in the Philippines, but also worldwide. Now, admittedly, addressing you on the topic of unifying the correctional system in the Philippines as part of this plenary is certainly as crucial as it is complex in nature. Yet, and I quote, "It always seems impossible until it's done." An obvious quote from Nelson Mandela. I want to get us started with in order to recall one example where alignment and unity was achieved despite initial vast difference. And namely, what I'm talking about is obviously the adoption of the so-called Nelson Mandela rules, which, and I won't get tired of reiterating this, have come to unite us all as universally recognized minimum prison standards. To be precise, we are actually talking about a quadriga of UN standards in this field because, as you know, the Nelson Mandela rules obviously come complemented by the Bangkok rules on the treatment of women in conflict with the law, the Tokyo rules as far as non-custodial measures are concerned, as well as, importantly, the just recently adopted Kyoto model strategies on reducing reoffending. Now, I've no doubt that many, if not most of you, are very familiar with the content of the Nelson Mandela Rules, but with your allowance, Justice Ong, let's refresh our memories with a short video to showcase the importance of these rules.
Prisons are closed settings. We often forget about those who live and work there. How we treat persons who are detained is very important, though. It mirrors our understanding of safety, justice, and human dignity for all members of our societies, including those in conflict with the law. The United Nations have always paid attention to the plight of prisoners. Already back in 1955, UN member states agreed to the standard minimum rules for the treatment of prisoners. But this was a long time ago, and a lot has happened since. In 2015, following 4 years of negotiations among diplomats and prison experts from all over the world, the UN General Assembly unanimously adopted an update version of the rules, now known as the Nelson Mandela Rules. Today, these rules represent the universally acknowledged blueprint for prison management in the 21st century. They outline minimum prison conditions, provide guidance, and set clear benchmarks for prison staff on how to ensure safety, security, and the humane treatment of prisoners. Let's remind ourselves that the closed environment of prisons creates vulnerabilities and a potential risk of abuse. The Nelson Mandela Rules therefore establish important safeguards for prisoners. For example, regular inspections of prisons by independent bodies must take place, including unrestricted access to all prisoners and the possibility to talk to them in full confidentiality. Furthermore, the Nelson Mandela Rules require that prisoners can engage in constructive activities and programs, and that they can be in continued contact with their families and friends, including through regular visits. Finally, let's also not forget the important work of prison staff, a demanding profession that is often under-recognized. The Nelson Mandela Rules give detailed guidance for tailored training for prison officers and recognize their work as a social service of great importance. As the custodian of the Nelson Mandela Rules, the United Nations Office on Drugs and Crime champions the promotion of the rules worldwide. Its guidance material and technical assistance projects with prison and correctional services across the globe all aim at turning the Nelson Mandela Rules into actual practice for the benefit of prisoners, prison staff, and our societies at large. To learn more about the Nelson Mandela Rules, visit our website and join our efforts to leave no one behind.
Thank you very much, and I hope it became clear to all of you why in UNODC we invest so heavily into not only promoting but also in operationalizing the Nelson Mandela Rules on the ground. But now, zooming in from the international to the national context and the topic of our plenary session, I would first of all like to refer to the most recent Philippine development plan, which actually provides quite a clear vision for the national correction system's future. As you can see on the slide, the plan not only commits to the objective of a unified penology and correction system, but also specifies, and I quote, that a single agency will be created to manage all national prisons, as well as city, district, municipal, and provincial jails, as well as to administer rehabilitation programs for convicted offenders. Now, this being said, the profound change that this notion would imply becomes clear when we look at today's status quo, which actually reveals three distinct and separate layers. So excluding community corrections, which is obviously also relevant here, this includes the Bureau for Jail Management and Penology under DILG, in charge of the custody of pretrial detainees and PDL sentenced up to 3 years. Secondly, the Bureau of Corrections under DOJ for PDL sentenced for more than 3 years. And finally, and importantly, a provincial jail management system under the authority of the provincial governors with a mandate pretty similar to the one of BJMP. Now, I have to say, from an international perspective, this is quite a unique system, as a vast majority of countries, except federal jurisdictions, which the Philippines are not, have one national prison or corrections administration. And even in federal countries, responsibility for prison management may be either delegated to federal states altogether. This is the case in my home country, in Germany, but also in Australia, meaning that there are distinct prison services per federal state. Or it may be divided between a federal prison system and state-based prison systems, such as in Canada or Argentina, based on what is defined as a federal or state-based or level crime. Now, in the Philippines, what we have is two distinct prison services that operate at national level and under different departments, with their responsibilities being based on PDL's legal status or length of sentence, whereas a third system is delegated to provincial government structures. And it seems, looking a bit back in history, that despite numerous legislative attempts to either integrate all services into one Bureau of Correctional Services, I think in 2008 there was a draft Jail Integration Act, if I recall correctly, or to at least integrate the provincial jail management into BJMP, something that was attempted just in 2023, have not passed or are still pending with Congress. And in UNODC, we would nevertheless see a continuous and actually quite pressing need to overcome the current fragmentation of the correctional system. The overall rationale behind being, or the overall objectives being, enhanced coherence and standardization, enhanced cost effectiveness, enhanced prospects for evidence-based decision-making across the system, as well as enhanced accountability and oversight. So, as you can see, all issues that would also serve as key ingredients to advance humane treatment, a rehabilitative approach to the treatment of PDLs, as well as decongestion efforts. So what does that mean more specifically? We would argue that if implemented properly, a consolidated corrections system would come along with, first of all, a coherent regulatory framework applicable throughout the system, including when it comes to key principles, core prison management practices, as well as safeguards. Secondly, it would support system-wide information collection, management, and analysis, be it on the prison population, be it on case management, as well as other prison operations. And we very much recall yesterday's discussion about the GCTA calculator, for example. Thirdly, consolidation would probably optimize rehabilitation programming and partnerships with external stakeholders, which currently tend to be pursued separately by each entity, in particular BJMP and Bucor. Fourthly, we would also talk about facilitating budget allocations as per system-wide priorities, including as far as investments into infrastructure as per unified standards are concerned. Fifth, a consolidation would also mean an alignment of training curricula and conditions of service of prison staff. Again, something that tends to differ significantly at this stage. And finally, we would probably also talk about streamlined internal accountability towards one department, coupled with system-wide external oversight from an independent inspection body. Now, please allow me to add two important qualifiers here, just to avoid that I will be misunderstood. First of all, this slide is not intended to convey that all of what I just said is subject to your correctional system being formally unified. All of these areas can and should be initiated and pursued within the current structure to create a more closely aligned system and to prepare the grounds for an integrated system. Secondly, I would also caution against the assumption that a full-scale integration of the correctional system as it stands now will be a straightforward exercise. Bucor and BJMP in particular not only come along with their own processes and management practices, but also with a distinct history, with a distinct identity and institutional culture, and that is something that does not change overnight. The point, in summary, that I'm trying to make is to showcase the significant benefits that would come along with progressively aligning the correctional system in the Philippines in preparation of a fully integrated system as envisaged by the government. Not in the form of a hasty move, but in the form of an officially promulgated, carefully planned, and gradually implemented process. So let me try to illustrate that with two images I normally use for other purposes actually, but which I think will also speak to the context in the Philippines. Now the first one, admittedly a rather abstract drawing. This describes a so-called complex system, a term that is used in sociology, economics, to describe a system that is composed of many, many different components that may interact with or that may rely on each other. So what does this mean for corrections in the Philippines? Well, I would argue that while BJMP, Bucor, and the provincial jail management system are distinct organizational entities for now, this will not prevent them from remaining interconnected and from impacting one another in practice. Either because PDLs and their related records will move between these entities, in particular after sentencing, because all Bucor, BJMP, and provincial jails require resources for what are similar overall tasks and objectives, and finally because these entities will approach similar either internal or external stakeholders for support and partnerships. So the point here being that the disparities we currently see between the different correctional entities will unavoidably affect the system's overall effectiveness, transparency, and accountability. The next one will be a little more straightforward, I assume. This image obviously relates to foundational requirements and proper sequencing of reform efforts. So remaining with this image, if we keep on adding elements after elements onto a system, the very foundation of which is unstable, the overall structure will remain shaky at best. And I would argue that the quality of its organizational structure will very much strengthen or alternatively weaken the foundation of a correctional system. So again, point here for this slide being that targeted reform initiatives, including those aimed at decongestion, the topic of our summit, will require an organizational structure that is supportive and not obstructive of timely and consistent implementation. Now let me, at this stage, briefly circle back in the Nelson Mandela rules and how we could promote their reflection during systemic reform in the Philippines. As you may know, UNODC has heavily invested in developing or translating the Nelson Mandela rules into practical guidance material, including through a compliance checklist that you see on the right-hand side, including through a scenario-based e-learning course, which I know that many of you are aware of because the Philippines are leading at global level when it comes to the use of this course by prison officials. But I want to briefly draw your attention to today, though, is the part marked yellowed in red, namely UNODC's Model Prison Act. And I admit, when preparing for my mission to Manila, I was in touch with my dear colleagues Martin and Nick, and I kindly asked them to share with me the national prison law of the Philippines. And I was surprised to learn that there is currently no statutory piece of legislation in the Philippines that would govern not so much a decision to impose pretrial detention or a sentence of imprisonment, but the actual implementation and management of it. I think this is, again, a very distinct feature in the Philippines in comparison to a vast majority of other countries, which have done so in the form of primary laws, a prison act, a corrections bill, a law on the execution of pretrial detention or prison sentences, whatever it may be called. And this is done in recognition of the fact that the deprivation of liberty, at least in those countries that have abolished the death penalty, constitutes the most severe and intrusive penal sanction a state can impose. So what UNODC's Model Prison Act does is to support, to group the Mandela rules into 12 chapters, the ones that you can see on the screen, and to suggest precise language for legal drafters on how to translate the principles contained in the rules into national prison legislation. Obviously not meant as a one-size-fits-all piece of draft legislation, but rather as an aide-mémoire for member states, how this could be done, what kind of topics should be regulated, and the principles and safeguards that should be reflected. I won't have time to go into detail on this publication today, but what I would like to encourage you to consider is drafting of or consideration being given to a prison bill or act for the Philippines, not only because incarceration deserves to be regulated in statutory law as opposed to leaving this entirely to subsidiary legislation such as prison regulations and the like, but also because I think this could be an important legislative initiative to contribute to harmonization of the correction system at large. Because obviously all prison regulations, regardless from which entity, would need to align with such statutory prison law. So, in conclusion, and I think I'm slightly over time already, I apologize for that. Let me reiterate that I do understand the complexity of unifying the correction system in the Philippines. Institutional change management of this magnitude is difficult. It requires strong leadership and perseverance. And importantly, I think it forces us to look beyond our individual institutions and onto the correction system at large. But what I tried to showcase in my presentation was, first, how the current fragmentation obstructs and undermines efforts to ensure a coherent system, how, secondly, it contributes to duplication and to draining resources in an environment where resources are scarce to start with, and thirdly, that there is no really a legal obstacle, nor a wide similar practice in international level that would point to a need to preserve the current status of the correctional system. So in short, I can only express our strong support for the government and JSCC to generate renewed momentum for tangible steps towards a unified penology and correction system in the Philippines, which UNODC would be pleased to support. I thank you very much for your attention. Maraming salamat.
Thank you, Mr. Meisner, for that enlightening discussion. Philip reminded us about what the Mandela rules are. He gave us an overview. And one item of information that was notable is his statement that the Philippines has a unique system compared to other prison systems in the world. He did remark that there are also fragmented systems in some other countries, but these are federal systems, and they are not quite like the Philippine system. And he also pointed out some of the benefits of having a unified system or integrated system, such as unified prison management practices, unified training, and rehabilitation programs. But it's also interesting that even if our topic is a broad one, is from fragmentation to unification, Philip pointed out that a prison system does not necessarily have to be unified in the sense of having a single agency, and it could be integrated in other ways. And that lastly, he pointed out, he brought to our attention the national prison legislation and the need for a law for the managing of prisons. So thank you, Philip. Our next speaker is Attorney Mary Grace Casano. She is the Executive Director for Legal Aid of the IVP Cebu City Chapter. She is also the Deputy Director of IVP National Center for Legal Aid. She has been awarded the IVP National Most Outstanding Legal Aid Lawyer for 5 consecutive years, from 2019 to 2024. So here to talk to us about what the current system is in the Philippines and what are the challenges arising from it, the challenges arising from the status quo. Please welcome Attorney Mary Grace Casano.
Thank you and good afternoon, everyone. Can we go to the first slide, please? My presentation is entitled From Silos to Standards Toward a Unified and Standardized Philippine Correctional System. Next slide, please. Before we talk about rules, about reforms, and about system, allow me to introduce to you Maria Aguanta and her story of living through the fractures of the Philippine correctional justice system. Maria is 32 years old. She is an educated, unemployed, a person with disability, a solo parent to 3 children. And like many Filipinos living in the margins, her birth was never registered. Without a birth certificate, she is already invisible in the eyes of the law, long before she even enters the justice system. Maria's story does not begin in prison. It begins in the police station. It was during the height of the drug war she was arrested for a non-violent drug offense. Like many others, she believed that arrest was quota-driven. No one asked if she was a caregiver, who would feed her children. No one screened for her disability, trauma, or drug dependency. There was no referral, no social services referral, no legal support. For law enforcement here, the job ended at arrest. Custody began, but care did not. Next slide, please. Maria's case moved to the prosecution pillar, but the prosecutors were overwhelmed. Public attorneys were stretched thin. There were simply not enough of them. Her case file was handled by hand, manual, fragmented, incomplete. There was no unified, contemporized case management system to hold her story together. Bail rules existed, but their application was uneven, excessive, uncertain. Others charged with bailable offenses remained detained. Law enforcement said that the delay was with the prosecutors. The prosecutors pointed to the law enforcement. The inquest stalled, and for many others, preliminary investigations dragged. The filing of the information was delayed because collaborative case buildup was never the norm. Maria remained in custody in the custodial facility, packed like sardines. To the law enforcement, the solution seemed obvious. Build bigger custodial facilities, add more space. Maria waited again. Next slide, please. Then Maria entered the courts. Nearly 90% of persons deprived of liberty were charged with RA 9165 under the Dangerous Drugs Act. Yet in Cebu City, there were only 5 designated drugs courts handling more than 8,000 cases. Courts could not simply be created because the power rested with the legislature. Judges, prosecutors, public attorneys were few. Additional judges were appointed, but they also shared the same courts, the same personnel, the same clogged docket. Appointments did not translate to dispositions. Cases piled up, hearings postponed, then postponed again. Then came COVID-19. Courtrooms closed, proceedings shifted online, but the jails had no digital infrastructure, no video conferencing hearing facilities, no stable electricity, no reliable internet, no training for jail officers of PDL or PDL paralegals. Rules were also forming for electronic evidence, for e-filing, for remote bail applications, and online hearings. There were no night courts, no 24-hour access for urgent matters. For some time, actually, lawyers were not even considered authorized persons outside their residence or APOR. The law moved forward, but Maria was left behind. Then the ground shifted. Earthquakes came. Flood followed. At least 2 halls of justice in Cebu City were damaged. Some hearings were held in tents. Others rented condominium units inside hotels, places where persons deprived of liberty were sometimes not even allowed to enter the very halls where their cases were pending. Access to justice became literal, physically limited, sometimes entirely inaccessible. Next slide, please. Finally, the judge issued a commitment order. Maria was committed to the Bureau of Jails Management and Penology, Cebu City Jail Female Dormitory, one of the most congested jails in the country. At that time, the congestion was 414%. Nearly 1,000 PDLs stayed there in a facility never built for that number and never built also for women. Next door, the male dormitory, designed for 500, held almost 7,000 with a congestion rate of 1,400%. They were packed tighter than sardines, most slept sideways. And in a mountain jail like Cebu City, water was rationed. Health facilities were below standard. And across the male dormitory stood another detention facility. It was under the same department, the DILG, but it was run by provincial government, staffed by personnel not adequately trained for jail management. Her arraignment was stalled, like so many other lives during the pandemic. 67% of the PDL nationwide languished like Maria in pre-trial detention. She waited again. By this time, her children were no longer just waiting. They were suffering. Because in a system without a Bangkok rules, without clear guidelines on the treatment of women in conflict with the law, no one assessed the needs of children left behind by mothers in detention. No child care plans, no coordination with the DSWD or Department of Social Welfare and Development, no monitoring of nutrition, schooling, or safety. Maria was detained, and her children were also punished. One of them even entered the criminal justice system. Only a wall separated Maria from her own child in conflict with the law. There were only 2 drug dependency examination physicians in the region and only 1 medical examination physician. And even when referrals were made, slots were also limited, delayed, and unaffordable. Some detainees were brought to the treatment center only to be returned to the jail to wait again until a slot has opened. Even others who were ordered only rehabilitation felt like there's another form of incarceration. ALS programs existed but uneven, livelihood programs limited, health and mental health care sporadic. Maria did not understand the court processes she was into. She did not understand her rights. Legal language felt foreign. Justice was present but unreachable. Some tried to help. IBP lawyers volunteered. Public attorneys tried their best. Law schools wanted to get inside. Civil society and religious organizations sought entry. But each worked within their own mandate. Each relied on incomplete or incompatible data. Each faced different rules, different requirements, and gatekeepers. Eventually, Maria pleaded guilty, not because she was, but because she was tired of waiting. She would be transferred to the Bureau of Jails Bucor facility under another department, the Department of Justice. And once again, she had to wait for the mitemos and the funds. Everything reset. Her records did not fully follow her. Her classification changed. Programs she completed not at all counted. So the BJMP and the Bucor shared mandates, but not departments, not systems, not standards, and not data. Rehabilitation was interrupted. Continuity was lost. Maria was not seen as a person moving through one system, but as a new file entering another. This is fragmentation. Different agencies, different rules, different databases, different philosophies. No unified correctional framework, no seamless transitions from arrest to prosecution, to courts, to corrections, to community. When Maria became eligible for release, freedom still required paperwork, endorsement, and for some classified as high profile, an approval from the Department of Justice under Department Order 652. Others sought help filing petitions for habeas corpus, costly, time-consuming, again, adding to an already clogged docket. Next slide, please. And when release finally came, there was no aftercare plan. No livelihood guaranteed, no integration roadmap prepared, parole and probation existed, but coordination was late and often incomplete. Her community wasn't ready because the system never coordinated with it. Maria did not fall through the cracks because Philippines lacks the law. She fell through because institution acted in silos. Law enforcement arrested, prosecution charged, court sentenced, jails detained, prisons warehoused, and the community was engaged too late. This is why we developed the Humanity Behind Bars Integrated Jail Decongestion Program, which we will show to you later. Because justice is not measured by how long Maria was detained, but whether humanity followed her in every step. Next slide, please. At this point, people will ask, what is a correctional system? It is not the jail that Maria entered, not just the prison she was transferred to. It is everything the state touches from the moment her liberty was taken to the moment that she tried to return home. Custody, classification, care and treatment, release, reintegration. But Maria did not experience a continuum. She experienced breaks, and in every break, it cost her dignity, her progress, and her chance to begin again. Next slide, please. Consider Maria's journey. Custody continuity was broken. Arrest to jail, jail to prison, prison to release. Each step reset her care, classification, and rehabilitation plans. Classification in individualized treatment was inconsistent. BJMP classified for security, Bucor for sentence management and parole and release system reassessed her again. No unified tool followed her. Health care stopped and restarted. Mental health, drug treatment, and reproductive care were facility-bound. Records never fully transmitted. Gender-responsive and family-centered care was also partial. Programs for mothers and caregivers existed but only fragmented. Reintegration and release planning began too late, and parole and probation, or GCTA, eligibility was only reviewed near the end. Next slide, please. After we see Maria's journey, we begin to understand what the Nelson Mandela rules and the Bangkok rules are. They are not abstract rules. They are blueprints of dignity and justice. The Mandela rules reminds us that every person deprived of liberty deserves human dignity. The Bangkok rules add that dignity must be gender responsive. Women in detention are not just inmates. They are mothers, they are caregivers, they are survivors. Rehabilitation is not a one-size-fits-all. Mandela rules demand individualized rehabilitation. Bangkok rules demand that it be trauma-informed, family-centered, and gender-aware, so that returning to society is safe and sustainable. And finally, on accountability, Mandela rules insist on inspection, monitoring, and independent oversight, but the Bangkok rules ensures that this oversight includes reintegration and community linkage. Together, these rules show us that detention is not just about walls and bars. It is about continuous care, respect, and justice. Fragmentation anywhere along this path is not just inefficiency, it is a violation of human rights. Next slide, please. From fragmentation to unification, Maria's journey shows us the human cost of fragmentation. So how do we unify? Let's take, for example, continuity of custody care. A unification would mean a seamless detention to release management where records, her programs, her care follow her as a person, not as a file. In terms of classification, a unified system would ensure one assessment across custody and community corrections, so her rehabilitation, release planning would be grounded in her true needs, not arbitrary resets. In terms of healthcare, a system-wide continuous care network with electronic linkages linking the BJMP, the Bucor, the DOH, and the LGU would have ensured that she would never fall through the gaps. Gender responsiveness. Unification would embed continuous protection for women and caregivers. Reintegration, a unified system, would start reintegration also on day one, connecting her to the community programs, livelihood opportunities, and social support even before she even steps out of the gates. And lastly, accountability. A unified system would establish a single system that is accountable, ensuring independent monitoring, grievance monitoring, and protection from start to finish. When the system follows this principle, Maria is not a file, not a statistics. She is a person whose dignity, whose care, whose future are preserved at every step. Next slide, please. After Maria's journey through the fragmented institutions, one might wonder, has anything changed since our first National Jail Decongestion Summit? And the answer is a resounding yes. We now have alternative sentencing programs, expedited case resolution, enhanced pretrial detention procedures, strengthened legal aid services, even restorative justice programs and practices that have expanded. Structural reforms, independent collaborations, and data-driven systems are also in place. But we hope that there is a system and an architecture to bind all these systems together. The solution is unification, and my colleague will later on discuss how we will also unify this. With unification, every PDL, every Maria experiences a continuous rights respecting, gender responsive, rehabilitative journey from arrest to reintegration. The Philippines actually is program rich, but it is systems poor. Why is it systems poor? It is because system actually prevents corruption. Next slide, please. To end, when we align our systems, connect our programs, and place dignity at the center, freedom becomes meaningful, rehabilitation becomes real, and communities become strengthened. And lastly, our correctional system delivers justice for all. So with that, I would like to let you see the AVP of our Humanity Behind Bars program, which is implemented in Cebu City for the IBP Cebu City chapter, being supported by our Cebu City Justice Zone. Kindly play, please.
Every person deprived of liberty shall be treated with humanity and with respect for the inherent dignity of the human person. As we all continue to grapple with the pandemic caused by SARS-CoV-19, the basics of the mandated health and safety protocols, wearing masks, observing social distancing, and washing hands are almost impossible for persons deprived of liberty who are time-locked in structurally challenged, if not defective, closed environments and highly congested facilities such as jails, prisons, detention centers, and community correction facilities. The IBP Cebu City Integrated Jail Decongestion and Management Program consists of the PDL Data Management System, a digital platform to inventory, monitor PDL case status, decongest jails, and facilitate efficient correctional facility management. The datasets entered into the portal consist of the jail facility, name, personal, and financial status of the PDL, case information, type of crime or offense, court and branch pending, handling lawyer, status of the case, date of commitment, time serving jail, imposable penalty, legal service requested, either to check status of cases, drug dependency examination, eligibility for parole, probation, plea bargaining, among others, case follow-up, issues and concerns, actions, referral to concerned sectors of the justice system, handling legal aid lawyer or LSP, and a data privacy consent form. The data is then exported, extracted, and extrapolated and referred to the concerned pillar of the justice sector. The system includes analytics that gives statistics and required data summary for ease in tracking information. Oplan Bilis Laya, a legal aid service to assist in the timely or immediate release of PDLs who have fully served their sentence or are eligible for probation, pardon, parole, or early release through the assistance of law student practitioners under the supervision of IBP Cebu City Legal Aid Service Group and law school supervising lawyers and the PDL paralegals and Cebu City Jail personnel. Jail digital infrastructure reforms for PDLs. As our justice system moves to a digital platform, the criminal justice system stakeholders in partnership with the public and private sectors will continue to assist the courts and the Cebu City jails to improve the virtual or remote video conference hearing facilities such as network infrastructure, internet connectivity, procurement of hardware and software, desks and chairs, cubicles, and air conditioning units in designated hearing rooms. IBP Cebu City's assistance to PDLs through its online legal aid or OLAP, e-Telegal Consulta, and the IBP Legal Aid Clinic toward the goal of efficient administration of justice and discharge of its public responsibility to render free legal aid service to qualified PDLs. Law in Action and LSPs in Action. The IBP Cebu City, consistent with its commitment to elevate the standards of the legal profession, will provide mentoring to LSPs by imprinting on all law students the qualities not only of a successful lawyer but that of a good lawyer. The IBP Cebu City, in partnership with the law schools, will prepare certified LSPs to acquire as many practical skill sets through tacit knowledge or law in action knowledge acquisition and imbibe on the LSPs the heart for legal aid service and pro bono lawyering. More importantly, Law in Action and LSPD's in Action address concerns on access to justice and delivery of legal services to the disadvantaged, the underserved and unserved sectors, especially during this pandemic. The LSP serve as our partners in helping realize the programs and objectives of the IBP Cebu City and the 5 pillars of justice that are geared towards effective and efficient administration of justice. Project Bagong Buhay is an integrative PDL welfare, reformation, and reintegration program through capacity building and psychosocial training, livelihood and responsible citizenship training, and job opportunities for PDLs to reintegrate into the community upon release. Recognizing the basic rights of PDLs to health and humane treatment, the IBP Cebu City chapter, in partnership with the Department of Health Region 7, Cebu City Health, and the BJMP, will ensure a functional tuberculosis and healthcare or disease management program. In IBP Cebu City chapter, we aim to break the fetters of injustice by forging sustainable partnerships, so together we can do more, better, and faster in meaningful service to the least, the lost, and the last.
Thank you, Attorney Mary Grace Casano. Your experience as a legal aid advocate and legal aid lawyer shows through your presentation. Thank you for showing us the human cost of fragmentation through a real-life story of a PDL. And I note especially the word that you used, the reset. Every time there's a transfer from one facility to another, there's a reset of prison and medical records, which impacts the welfare of the PDL. And you also showed us the impact on our compliance with international standards because of this system. So thank you, Grace. Our next speaker is Professor Raymond Narag, PhD. He is Associate Professor, School of Justice and Public Safety of the Southern Illinois University, Carbondale. He is also the Graduate Program Director of its Criminology and Criminal Justice Program. Professor Narag has first-hand experience of our prison system, not just by observation from the outside, but, as he mentioned earlier in the first plenary, by being himself a detention prisoner in one of our city jails for several years, until he was declared innocent. He was acquitted. So Dr. Narag brought to bear that experience in his studies, in his further studies of our prison system and prison reform, not just in the Philippines, but all over the world. And because of that combined experience and knowledge, Dr. Narag is now the brilliant professor that he now is. So I now present to you to talk to us about still touching on the status quo in the Philippines, but focusing on where do we go from here after what we've heard, and what obstacles do we face. I now present to you Dr. Raymond Narag.
Thank you very much, Justice Ong, for that very heartwarming introduction. And to all our guests here, thank you very much. It's really an honor and privilege for a former person deprived of liberty, a person's restored of liberty, to be sharing here today. This is a dream come true. I always imagine when I was still an inmate at the Quezon City Jail, one day I will address the honorable men and women running our jail and prison facilities, our correctional system, with the passion, with the care that we desperately deserve. So my research and my ongoing engagement with the parole and probation, with the Bucor, with the BGMP, with the different actors in the criminal justice system has been the impetus of this presentation. When GOJAS and UNODC tapped me as one of the researchers for that study, together with Attorney Romel Iyok Abitria, about what ails the criminal justice system, the result was this summit. Summit 1, please address the concerns raised by Dr. Narag and Attorney Abitria. And since Summit 1 and Summit 2, we have grown leaps and bounds. And so I'm very, very happy that our efforts to document the problems, our efforts to find solutions have finally been bearing fruit. And today we are given the most difficult topic of all, a topic that everybody says they want to do it, but everybody cringe on how to do it. I've been talking to jail officers, to prison officers. Is it really possible to unify? And they always said, yes, but. All right? So this topic will now be describing the elephant in the room, right? Our UNODC expert gave the very big picture. Why do we have to unify? Our local expert says it from the local experience. This time around, I'm going to show you from the perspective of a former PDL. So let's start with first. So again, the Philippine correctional system, as mentioned already, is divided between the BGMP that has run around 487 jails, district, city, and municipal jails, and also the Bucor prisons with 7 national penitentiaries. And then we have more or less 70 plus provincial and sub-provincial jails. Of course, these are differently managed. BGMP, again, DILG, Bucor, the DOJ, and then, of course, the provincial jails under the provincial governors. This division reflects historical and legal separation rather than correctional rationales and main goals. I was telling other experts before that before 1990, we only have one Bureau of Prisons, one Bureau of Corrections. It was only in 1991 when they introduced the Bureau of Jails, right? When we separated it from the Office of Jail Management and Penology, becoming the BGMP. Initially, the BGMP is a very little population. When I was an inmate in 1995, the jail population of Quezon City Jail was only 700. When I got released, it's already 3,200. Manila region, BGMP, less than 10,000. When I got released, more than 30,000. The nationwide BGMP, less than 20,000 during the time. Now, it's already 140,000. So before, nobody noticed the BGMP. But it started in 2000, the BGMP population stood up. Now, BGMP is actually bigger in population than the Bucor. 114,000 for the BGMP, 53,000 for the Bucor. So suddenly, wait a minute, we are doing the same thing, we are competing, and we are not integrated. So persons deprived of liberty move across jails and prisons, and then either parole or probation, but you are correct. It's always like, I start, magsisimula ka po muli. And then the policies, the programs, and data systems remain fragmented. So let's just look at this a little bit. So this, in a nutshell, is my representation of the Philippine criminal justice and correctional system, and see how fragmented it is. So we have the detention centers. These are just the holding centers. So the PNP, by the way, they have their own custodial centers now. And it's also growing. They want the inmates to be there. They don't want to transfer it to the jail. The NBI has its own custodial facility. The PADEA and also the Bureau of Immigration. By law, if you look at our revised penal code, they should only be considered detention centers or holding centers. They should be there for 12 hours, 18 hours, or even 24 hours, and then the court should transfer them in our jail facilities. In reality, based on my research, some inmates on average stay there for 2 weeks, 1 month, sometimes 1 year, they are in these detention centers. Now, of course, they are transferred to our jails. And in the Philippines, the judges in the provinces could either commit you to a BGMP jail, district, city, or municipal, or to a district jail, or to a provincial prison, a provincial jail. There's no rule or rhyme for that. Either kung saan na maluwag, doon i-commit ng judge yung PDL, right? And then, of course, when they're convicted, they are transferred to the Bucor. As mentioned earlier, if it's 3 years and above, they are transferred. So ideally, in the BGMP, if the court processes are swift, at sinunod natin yung speedy trial law, where it says a certain time limit at maximum 11 months, convicted and transferred ng PDL, we should not have any problem at all. The BGMP remains small, remains a detention center. But because of the delay, on my study, it takes at least 3.2 years on average if a case is non-bailable offense in order to be disposed of by the court. I even documented up until 19 years, 24 years, undergoing trial and still unconvicted. I myself stayed in jail for 6 years, 9 months, waiting for my case disposition. And so that's the reason why we have a bloated jail population. And then, of course, from the Bucor, you have to apply for boards of pardons and parole in order to avail of parole. And then you also directly apply to the court for probation. And so this is where the fragmentation comes in, right? Because some of the data from the jails are not sufficiently transferred to the Bucor. For example, an inmate stayed already for 20 years. His name is Alex Soliano. Ang sabi po ng Davao, tapos na niya ang kanyang sentence with good conduct time allowance, 40 years na po siya. And then dumating sa parole, sa office of the Bucor, sa PDPD, and what they found was that there's a missing data or incorrect data nung galing siya sa jail. Why is that? Hanggat ngayon, hindi siya lumalaya. Supposedly, lumaya na siya noong July of 2025. So these are examples of what we have found to be some sort of fragmentation. So, here it is how it is manifested. So separate institutions govern same correctional population. So again, different data systems, data management, and case records are being processed. So even the alpha list in the jail is quite different from the alpha list of the Bucor. Iba yung framework, iba yung questions na tinatanong, iba yung data na ina-analyze. So even that, magkaiba na yung kanilang data management system. Programs are not transferable across jails and prison facilities. You finish your, for example, ALS in BJMP. Of course, dapat pagdating mo sa Bucor, magha-high school ka na or magka-college ka na. But because sometimes even the programs are not transferable, nag-ALS ka na sa BJMP, pagkatapos mo sa Bucor, mag-ALS ka ulit. Uulitin mo. You just repeat the ALS. Why? Because you want to generate GCTA. But the program is offered the same. No unified correctional philosophy or case management framework. Even in the BJMP itself, and even the Bucor, a warden will define kung anong gusto niya. Kung anong pamalalakad niya is a pro-rehabilitation, then he will manage the facility in a very rehabilitative way. For example, Director DJ Katapang is very rehabilitative. But previous to him, Director Bantag was very, very punitive. Right? And so even within the same system, nag-iiba because we do not have a stated correctional philosophy that everyone should adhere. It is person-specific, subject to change. Bagong hari, bagong ugali. And that's the reason why kaming mga inmates nagra-riot. Why are there riots? Why? Because a warden comes, okay, ipasok niyo ang kubol, ipasok niyo ang dalaw, ipasok niyo lahat ang makakatulong sa inyo. And then another warden comes, no, by the book, no visitors, no electric fan, everything. And so the inmate now is confused. Bakit inalaw ng previous warden and this warden now doesn't allow it? Why? Because we do not have a unified correctional policy. The policies of the BGMP, for example, bawal magyosi dati. Bawal pumasok ang dalaw sa loob. And then masyashock sila, sa bilibid, inaalaw lahat. And then of course, bilibid now changes policy. And then everybody is also confused with the system. So that's how correctional fragmentation translates into the lived experiences of PDLs. We are confused, our families are at a loss, we don't know what to do because it changes from time to time. All right? Now, education and livelihood and therapeutic programs differ between BJMP. The good thing is the BJMP has therapeutic community, that's good, and it's also implemented in the Bucor. However, the form of therapeutic community is quite different from each other's. Even the name, PDL for BJMP, PSDL for the Bucor, right? So differences of terminologies there. Often starts after transfer to jail to prison, no continuity in treatment, education or skills development, and rehabilitation plans are institution-based, not person-based. So for example, if the PDL finishes one livelihood assistance program, it's because that's the only program that's being offered in that facility. It's not because that is what is needed by the PDL. Okay, another one that I've initially mentioned is the delays in the transmitting of cases upon transfer. Good thing now, because of the constant communication of the BGMP and the Bucor finally realized that when an inmate or a PDL is transferred from the BGMP to the BGMP should provide all the documents needed. And we believe there are 14 to 16 documents. For example, entry of judgment, certificate of detention, certificate of good moral character. All of those should be completed because if you stay already in prison for 20 years and you are about to be released, they check all those documents. And if the BGMP or the provincial jail forgot or failed to bring those documents, you cannot be released. If your entry of judgment is missing, even if you have already maxed out your sentence. It is because of the fragmentation of our program. Loss of incomplete records affect classification and eligibility decisions. Manual and non-integrated systems increases errors and delays. For example, I have a fellow inmate. He stayed already in jail for almost 25 years. But his documents is already very old, and you can no longer see what year with us. He was arrested 2001. The prison interpreted it 2011 because the 0 is not feasible. It looks like 1. So that removed 10 years of his sentence. So he had to serve 10 more years. And so he has to go back again and again to the jail. Please produce a new certificate of detention from the jail. And the jail says, we don't have any more records. Because nasira ang records, nasunog ang records, whatever happened to their records, they could no longer reproduce the record they submitted 20 years ago. And so the inmate now languages unnecessarily because of that. Eventually, we found a way to overcome it. Different interpretation of the good conduct time allowance. All right, we talked about the GCTA yesterday, right? And what happens is that when the inmate already is about to be released and the computation is already done, the Bucor is very, very meticulous, which is, of course, necessary for them. But sometimes they find that, wait a minute, the jail that the inmate came from was very, very liberal. He gave 10 more years, 15 more years. So in the perspective of the Bucor, this is a misinterpretation of how to calculate. And so they would go back to the jail, and then the jail would now say, no, this is our correct interpretation. So the issue there is, who wins? Sino masusunod? BGMP interpretation of GCTA o Bucor interpretation of the GCTA? So please, mag-usap po tayo. Let's train each other so that we have a common way of computing GCTA. All right? So confusion, okay, last 5 minutes. Transfer, etc. Okay, leads to dispute, grievances, and delayed releases. And then, ito pa. For all of you, you only see the formal elements of prison life. For us, PDLs, ang nagmamanage talaga sa buhay namin ay ang pangkat, ang gang system. Right? Because we deal with the gangs every day, they deal with us, we survive with them. All right? But there's no unified intelligence gathering, sharing between the BGMP and the Bucor in terms of gang. Gang affiliations may be reassessed or ignored later. Some jails don't recognize the gang. They remove the gang. Some jails embrace the gang. And in prisons, they cannot work without the gangs. So what is it? Anong polisiya natin sa gangs? Right? If you ask the BGMP, they will say, that's a problem we inherited from the PNP. If you ask the PNP, they would say, that's a problem we inherited from the Bucor. Because when they are released from the Bucor, they are rearrested by the PNP. And when you ask the Bucor, they will say, that's a problem forwarded to us by the BJMP. All right? So again, it leads to weak coordination. So again, the Mayores system. How do we deal with the Mayores system? What is the policy of our correctional system in this regard, right? Because without dealing these realities, whatever we do in our prison, jails, and even detention centers, if we do not discuss this in a legitimate, formal way, we are going to have a fragmented way of running our prisons. So the impact, it has already been mentioned. It leads to delay releases, misclassification, interrupted rehabilitation, and weak accountability and oversight. Now, so what should we do, right? So again, the consequences is delayed releases, leads to overstaying, congestion, and fragmentation. And now I've conducted many studies and interviews. What should we do forward? So correction is a continuum from arrest to release. PDL should have a single correctional case trajectory. There should be unified standards to improve efficiency, fairness, and legality, and human rights-based corrections require institutional coherence. Ang daling sabihin, pero ang hirap gawin. And so here I created some models, right? So we know the problem, we need to solve it. But how will we solve it? First model, full unification into one bureau. Oh, mahirap ito. Why? BGMP and Bucor merge into one single correctional bureau. Unified leadership, isa na lang ang director, general. Unified budget, isang training school, and isang operations framework. Single correctional philosophy and policy framework will also be in place. This is the most structurally transformative option. And then it will be considered Bureau of Corrections and Jail Services. What are the pros of this? Well, it's a complete policy and operational integration. It has a unified data, documentation, and case management, consistent GCTA, gang, and security policies, and clear correctional continuum from jail to prison. This is how most jails and prisons are structured all over the world, except for the Philippines and the United States. In most countries, there is only one. However, this is probably the most difficult thing to do at the current moment. Why? It's highly complex organizational merger. BGMP and Bucor have their own institutional integrity and history, right? Different personnel cultures, ranks, and compensation. 4-star Director General ang Bucor. 2-star Director ang BGMP. That's just one difference. So who will be the lead agency just in case, right? How could you merge them practically? Leadership questions, political and bureaucratic resistance will be very, very problematic. Second model, transfer the provincial jail to BGMP, step one, and there's a bill right there that does that, and then transfer BGMP to DOJ. So you are simply transferring one agency to the next. All right? So provincial jails being absorbed by the BGMP because provincial jails is actually a forgotten, redundant agency that should have been transferred a long time ago, either to the BGMP or to the Bucor. And then BGMP transferred to the DILG, from the DILG to the Department of Justice, and BGMP Correctional remain distinct but aligned. And this is what we call most operationally feasible reform. And then, of course, Yusek Deo, who is the Undersecretary for Corrections Cluster, could supervise this. Is that right? Is that direct? Yusek Deo. What's the pros of this? Well, it preserves organizational integrity, allows jails and prisons under DOJ policy and leadership, allows sharing of land. Why? Because the strength of the Bucor is its very vast land resources. BGMP, wala po kayo gaanong lupa. Tama po ba? What BGMP has is a very disciplined personnel that should also complement the Bucor's personnel. Allows sharing of facilities and training schools. The BGMP has a very good training school already that could be maximized by both. And then finally, it could lead to lower resistance and phase implementation possible para hindi ma-high blood ang mga Bucor and prison officers natin, jail officers natin sa pag-i-integrate. Pagsamahin mo lang muna sila sa isang department. The cons, however, is that it does not fully eliminate institutional separation, requires strong DOJ coordination, risks partial integration without enforcement, and may still require legislative adjustments. And then this is the third model. Create a Department of Corrections. All right? And here you could establish a new department where it includes not only the BJMP, the Bucor, but it also includes parole and probation and the boards of pardons and the parole. And the provincial jails can be absorbed by BJMP and still become a provincial jail, or a provincial jail can be absorbed by the Bucor and becomes a provincial prison. All right? In that way, you don't have to transfer PDLs in the Bilibid if they are sentenced with low sentences and they can remain in their own respective provinces. The pros of this is end-to-end correctional governance under one department, strong alignment and custody, unified policy and training, and clear accountability and strategic direction because they are under one correctional supervision. The cons, it might be hard to create a new department, right? It will be more, from the perspective of the national government, expensive. Significant political, fiscal, and bureaucratic hurdles, long transition period, and risk reform fatigue if not well managed. My time is up, so I'm going to end. So again, these are things that I've learned as a PDL. I've learned through the process, right? Whatever you do upstairs, you may have a very good goal. You may have a very good intentions. But we who live this process, live it in a different way. Live it in a very challenging way. As Dwayne had said, your intentions may be good, but it harms us nonetheless. So again, please take those into considerations. Listen to PDLs. Listen to their experience of transferred from jail to prisons to police and so on and so forth. Probably they could share some exciting new trajectories. Maraming salamat po, and hopefully we'll have a meaningful discussion today.
Thank you, Dr. Narag. That was a very enlightening discussion. Many of the points of Dr. Narag reinforces the points earlier made by our earlier speakers on the status quo and the problems with it. But maybe one thing you did not expect is the impact of fragmentation on the policy on gangs. So that's something new. And then, something worth noting is Dr. Narag's statement that the integration, madaling sabihin, mahirap gawin. Now, for the non-Filipinos in our audience, it simply means easy to say, hard to do. And then he presented three models of possible ways forward. And one is the full unification under one bureau. The second is the BJMP and the Bucor being under one department, DOJ, with provincial jails being made part of the BJMP. And the third model is having a Department of Corrections where all these agencies will be placed under. So with that, I'd like to open the floor for questions from the audience. And if you don't mind, I will now join them so that the transition will be easy.
Magandang hapon po. I am Assistant Secretary Al Pereras, the Deputy Director General of the Bureau of Corrections. Yes, we would like to unify penology. We have this is the marching order of the President. But we would like to take exemption to some of the statement of Professor Narag regarding our way BJMP and Bucor has been recognizing the problem. Hindi po kami nag-aaway ng BJMP. Actually, palagi po kami nag-uusap, wala po kami disagreement and with respect to the GCTA, just what like Professor Narag had portrayed to us that we have several differences with BGMP. Wala pong katotohanan yon. Actually, kami po at ng BGMP palagi nagkakasama sa mga, in all our meetings. Pati na po dito sa integration na itong the BGMP, the Bucor, and the Provincial Jail. Actually, we have a TWG at the Department of Justice. Nag-uusap po kami tungkol dito sa integration, pero wala po kaming pag-aaway. Ayun lang po gusto ko sabihin na maganda po ang pagsasamahan namin ng BGMP. Maraming salamat.
What's your name again, sir? Sige. Maybe, thank you. Sir. Yeah. Let's give Professor Narag an opportunity to respond.
Thank you very much, sir. I stand corrected if I say that nag-aaway ang BGMP at Bucor, which is totoo po, hindi ko yung nag-aaway. It is from the lived experiences of the PDL. It is how we experience it. Because if we go to the jail, itong sasabihin ng jail, ganito ginagawa nila sa Bucor. And if we go to the Bucor, ito naman sila, sinisisi naman nila ang jail. So from the perspective of the PDLs who suffer the differences of procedures of the BGMP and the PDL, we thought that they are quarreling, they are fighting. But that's only from our own lived experiences. From your lived experience, on the other hand, you're correct, sir. No questions asked there. Maganda ang samahan ng BGMP through the years, and I've observed the professionalization and the synchronization of efforts between the two. But still, gaps do happen from the perspective of the PDLs. So I stand corrected if I came up very negatively on that aspect. Thank you very much, sir.
Thank you, Prof. So what did I tell you? You know, at the start of our session, I said, I'm confident the blood in your stomach will shot through your head in no time. So my confidence was vindicated. So yes, ma'am. Please introduce yourself before asking your question.
Janet Padua, Regional Director, DOJ, Parole and Probation Administration. So the presentation, as always, is good. Just a humble sharing that decades ago, the unification of the institution-based agencies has been proposed several times and several attempts. There were the propositions for the Department of Corrections, by the BGMP, by the Bucor, and even the Parole and Probation Administration. I should know because I was a part of the proposals then. But the problem that I have discovered at all times is the issue on who shall lead. So in that event, after several meetings, after several conferences, after convening, it was stopped because nobody decided who shall lead the unified department for that purpose. Now, may I respectfully ask from anybody, even you, Dr. Narag, in your expertise, may you recommend to us the specific steps, not considering the issue on who shall lead or other things that you have mentioned a while ago. But for me, before I ask my question, I would like also to say that we at the corrections pillar are really unified. We are trying our best. In fact, the results of our work from then to now is very successful because we have a good, very, very good leader at the corrections pillar, DOJ, our very own Yusek Dio Marco. So, yun po, palakpakan. Sir, boss, love ko yan. So, this is now my question. Can you give us a specific detailed recommendation, step, considering this issue? What are we gonna do, considering that you're an outside you have an outside perspective? Specific step. Can you give us specific step of action to unify this department? Because we're doing our best. But can you give us an idea from the perspective of Director Narag? Thank you po.
Okay, let's give an opportunity for our other panelists to answer.
Well, thank you very much for the question, and that's obviously the big elephant in the room, right? I mean, so yes, we have outlined all the expected benefits, but what now? And I think that's the situation the Philippines have been in for quite some time. So Obviously, this is something also for JSCC to consider, including in the outcome declaration of this summit. Certainly not the details of what is to happen, but definitely that's an issue that is to be further pursued. And I think building on Dr. Narag's presentation just now, who actually outlined some 3 potential models, I think it would be extremely helpful to conduct a more detailed study to add some more meat to what these different options would come along with in terms of resource implication, in terms of complexity, in terms of structural changes, etc., and present that to policymakers who are able to take a more informed decision thereafter. Because my perspective, and please do take it from an outside perspective, what I can offer in close coordination with field-based colleagues here in the Philippines is an eagle's eyes perspective. But in my view, so far the discussions have been a bit more focused on so who will merge with each other and who will take the lead on what. But apart from that, it still remained a little abstract. And I think a more detailed study on these 3 models, for example, could add some meat to it in order for policymakers to take a more informed decision. But no doubt, it will take political leadership for a decision to be taken. Thank you.
All right, thank you very much, Philip. Yes, Ma'am Jeanette, this is a very, very important question that if we really want to move forward, we have to answer it as honestly and as openly as we can. I could build with what my 2 colleagues here had mentioned, is that first we need to build the correctional bill or the prison law that we are going to develop. As a country, we don't know specifically what is it that, how do we envision a model correctional system, all right, that has the principles of risk assessment, classification, housing assignment, programming, case management, and documentation. So we need to build first, right? Create our model philosophy of punishment and how we are going to administer it. We sit down together and develop that. And from there, let's see how the BGMP could fit to that new model. How the Bucor could fit to that new model. All right? Because right now, if we merge the BGMP and the Bucor, the BGMP is like a square and rectangle. The Bucor could be like round and circular. And if you combine them, it will create the mess that we have seen earlier. But now what we could see is that if there's a modified correctional model, and these are its characteristics, these are its standards, these are the training needs, these are the personal needs, these are the land needs, these are the table of specification needs. And then we can see what are the strengths of the BGMP here that we could transfer over there. What's the strength of the Bucor here that we could be transferred over there? So for example, Bucor, ang daming lupa, right? So there, one of the requirements of a new correctional model is land, for example, land resources. And the Bucor has that, so put it in here. One of the requirements naman ng new correctional facility is a training school. BGMP has a very well-functioning training school, so that could be placed in there. So this is what I suggest. Let's close our eyes. Let's forget we are BGMP. Let's forget we are Bucor. Let's forget we are PPA or whatever. In a new world that we want to bequeath to our children, in a new world we want to say that our correctional system work. Itong gusto natin magawin. What can we sacrifice as a person, as a personnel, so that I could transition from here to there? Right? So forget muna pansamantala, so that we could create our model correctional system that works. Of course, that takes a lot of sacrifices, that takes a lot of letting go of our privileged positions probably, but in the future, we could go away from the fragmentation that we have self-imposed on ourselves and continually to harm us. And it will continually to harm our future children, the future Filipinos, we will continually harm with our fragmented system. So yun po yung sagot ko dyan, Ma'am Jeanette. Let's just take it back a little bit. Close our eyes. And let's be Filipinos who love our country and then do the sacrifice for this transition. Okay po ba yan, ma'am? Thank you.
If I may just add, ma'am, please consider having a dialogue. But in coming up with the dialogue, I want you to change your perspective. It's always the case, we want to implement policies from top to bottom. But try to change it. Go from the ground up. You try to invite the people who work on the ground, get their information, get their ideas about how you can change it. Like, for example, you have best practices in the Bucor, you have best practices in the BJMP. You can share those best practices. Out of those best practices, you come up with what should be a unified correctional system, what works, what do not work. No? And with that, it becomes more holistic because you try to include the personnel. You don't just consult the heads of the bureau, the heads of the pillars of the justice system. Try to include your personnel and especially the PDL and the prisoners themselves.
Thank you. So it's interesting. It seems like neither of the two questioners so far question, the objective of integration in principle. So it's just a matter of how to do it. And with the first questioner, the issue only was whether they're fighting or not. So they're not fighting. So that was settled. But the principle is still there, it seems. So yes, ma'am.
Yeah, I just like to share how the policy that the BGMP is has sole control and supervision over jails in cities. While waiting for the national law on the dignity of women deprived of liberty, in Davao City, we took the initiative of passing a local ordinance based on the Bangkok rules. It was a two-year work, and it was passed by our city legislature. It was the work of the women's groups, including the Davao City Justice Zone, and actually the BGMP was part of it. Even the city legal office, and then it was vetoed by the city mayor. So, and the tenor of the veto is that the city does not want to encroach on the mandate of the BGMP. And that maybe it's a surplusage to colonize the services that can be given by the BGMP. But in truth, in Davao City, for example, I'm sure in your cities also, the detention centers under the PNP, I think it's called lock-up jails, that's under the office of the city mayor. And these are the detention cells which has no beds, no food. And it was said earlier that sometimes detainees stay there for a year or more because cases are not filed. So there must be some. Well, there are national bills being filed, and I hope it will really be passed. Otherwise, we go back to the office of the city mayor and convince that it's not colonizing the mandate of the BGMP. It's a kind of integration, or it is not against unification. Thank you.
So you're from the Davao City LGU, ma'am?
Yes, I'm from Filipina Legal Resources, Davao City.
Okay. So thank you. So it was an input more than a question. So thank you. Unless our panelists want to comment on that, no?
All right. Yes, that's a very good initiative at the local level. While a national correctional integration framework is ideal so that it will guide the local, but if the national is still on the works, and if the local is already up and running, then by no means we need to support these local initiatives. That's the reason why we have the justice zones, ma'am, right? That the justice zones will coordinate with the police, the prosecutors, the judges, the defense lawyers, the BJMP, the parole and probation, so that they will identify what are the gaps in the services and then how they could make their systems work more efficiently. So that's correct. We have to think also from a site level, from a local level. If we could integrate our correctional management and even our criminal justice system at the local level, so much the better. The Justice Lab in Region 10, that's a very good example of coordination and cooperation at the local level. So with you in Davao City, ma'am. Thank you.
Ma'am, thank you so much for the initiative. If it was vetoed by the mayor, I believe that the Justice Sector Coordinating Council will not veto it. You may submit your proposal because I know that the Justice Sector Coordinating Council is coming up with a manual for women in conflict with the law, for the proper treatment of women in conflict with the law, and you may very well add your input so that the JSCC can also learn from the experience of your organization. Thank you.
Maybe just one last remark that was made about the bottom-up approach that should be also used. I would fully agree with the value of it. I would also strongly argue for a top-down parallel approach. Why I'm saying that? Don't ask entities to reform themselves. I think if we leave it at that, we will continue to be embroiled in defending each other's territory. That's something that entities do. I'm talking about institutions at both national and international level. I'm working at the UN, I can see parallel tendencies. So there needs to be, at some stage, somebody at Secretary of Justice, together with Secretary of Interior and local government, or even beyond, somebody needs to remain seized with that and be watching over it, and if necessary, taking a decision of the overall direction. That I think can be very much and should be complemented with the bottom-up best practices that could be taken from here, transferred there, etc. But I would caution against leaving it to the system as it stands now to reform itself. Thank you.
Thank you, Philip. I think we have less than 3 minutes left. So, any more questions? Because if not, I will use my prerogative as moderator to ask a question. No? None? Okay. Well, just one question. Anyone can answer. In the Nelson Mandela rules, there's a provision there saying that untried prisoners should be kept separate from the convicted prisoners. So how would that bear on the options that are on the table for integration? How would an integrated system look like and still observe that provision in the Nelson Mandela rules?
That's a very good question. So in most facilities all over the world, they follow the principles of effective prison and correctional management, where you have classification, you have housing segregation, you have programming, and then you have case management and documentation. When the person first arrives, you ask first the legal status and then the criminogenic needs. So for example, if you are first-time offender or you are pre-trial detainee, you are segregated and you are going to have a separate treatment based on those needs. If you are recidivist, you are pabalik-balik, high criminogenic needs, and then you have a lot of programs, education, livelihood, substance abuse, then you have to undergo those programs. So for example, in a facility that have a unified system like the one that I visited in Belgium last September, so what you see is that this is a prison of 1,200. There's a wing for undergoing trials. And there are specific programs for these individuals. And there are wings for sex offenders. There's wing for those people who want to study. There's even a wing for those people who are tending the gardens. So there's a way for us to segregate effectively and efficiently, even if the convict and the pretrial detainee population are in just one facility or one compound. That's it.
Maybe just to add to that, Judge Ong, the separation of pretrial detainees from sentenced prisoners in the Nelson Mandela rules fall into the same category than the need to separate men from women. So this is something that is really different from classification. That's the generic separation you do within your system on the basis of legal status and on the basis of gender. Then when it comes to classification, we further look into individual risks and needs assessments, but indeed most jurisdictions some have separate facilities altogether, but under the same correctional system for pretrial detainees only, whereas others have separate wings within the same prison facility where you have pretrial detainees being kept separate from sentenced prisoners. But again, the rationale behind having a unified system is that many features of detention will apply to both pretrial detainees and sentenced prisoners. So it does make sense to have one overall authority overlooking it.
Thank you very much. That's all the time that we have. And I hope you were all enriched by our discussion. I certainly was. I would like to thank again our panelists. Thank you very much for sharing with us your expertise.
Thank you for that very impassioned discussion. Thank you to our resource persons, Philip Meissner, Attorney Mary Grace Casano, Dr. Raymond Narag, and of course our moderator, Court of Appeals Associate Justice Michael Ong. Thank you. Before we proceed to our breakout session, we'd like to take this opportunity to invite you to listen to our podcast on jail decongestion. And we have our guest for today. The episode will be released this afternoon, Dr. Narag. So if you can't get enough of Dr. Narag, invite you to listen to his podcast. The topic is Journey of Justice, Surviving Detention, Advocating Decongestion. And last week's episode was on finding solutions to jail and prison overcrowding through collaborative action. We had CA Associate Justice Jat Karingal, Chief Superintendent Roger Boncales of Bucor, and Jail Superintendent J-Rex Bustinera of the BJMP. Meanwhile, for the breakout sessions, Session 1 on correctional monitoring, now and towards the NPM, it will take place here at the plenary. For Session 2, setting a new jail and prison building code, it will take place at the Rigodon 1, which is just behind this stage. Session 3, regulation of prison occupancy, Rigodon Ballroom 2. And lastly, Session 4, independent prison capacity measurement in addressing prison congestion, Rigodon Ballroom 3. So if you can please make your way to the breakout session rooms. We will reconvene later at about 4:30 for the closing ceremonies. So we hope to see you then. Thank you. Good afternoon.